Good morning, everyone, and welcome to our webinar on maintaining a drug-free workplace. I'm Steve Wilson, Director of Communications for the New Jersey Business and Industry Association. And with us today are Angelo Valenti, Executive Director of the Partnership for a Drug-Free New Jersey, and attorney Steve Trimboli, a partner in the law firm of Trimboli and Gruzanowski. A few housekeeping matters before we get started. Today's webinar is being recorded and will be automatically emailed to you along with a copy of the presentation. You can download the presentation now if you prefer. Just click on the handout tab on your screen. If you have any questions during the presentation, please click on the questions tab and send them to us. We will be taking them after our featured guests are done, but don't wait till then. You can write them down and send them in as they come to you. So now, to get things started, I'm going to turn it over to Angelo Valenti.
Good morning, Steve. First, I want to thank the New Jersey Business and Industry Association for giving the Partnership for a Drug-Free New Jersey an opportunity to bring this important information to your members, and we hope that by the end of this seminar, they'll become much more knowledgeable about how important it is for all businesses, no matter what size, whether they have 2 employees, 200 employees, or 2,000 employees, to have a drug-free workplace practice and also a plan for their employers and for the protection of their companies. In no way is a drug-free workplace intended to be punitive. In fact, we encourage people who are setting up a policy or have a policy to make sure that policy includes providing an opportunity for individuals who have addiction problems to be able to get help and seek treatment. Now, the presentation today is for educational purposes only, and it's not intended as a substitute for legal advice. Any employer confronted with a specific issue pertaining to drug use in the workplace is strongly advised to obtain and consult with a competent counsel experienced in the field. And we have one of those counsels that are here with us today, Steve Trimboli, who you'll hear from in a few moments. And Steve has been working in this field for many years in the state of New Jersey. Now, why do we need a drug-free workplace policy? Well, think about this. The U.S. represents 4% of the world's population, 20% of the world's wealth, and consumes 70% of the world's production of illegal substances. So we know throughout the country and in the state of New Jersey that illegal substances are being consumed by many, many individuals. And who are these individuals? Well, 70% of the estimated 14.8 million Americans who use illegal drugs are employed. And they're employed in companies, small, mid-size, and large companies. We also have seen since 2012 through 2014 that the drug positivity rate is increasing. And what that means is that there are more people that are testing in the workplace and are testing positive for drug use. Now, we believe that when the issue of workplace substance abuse is addressed by establishing a comprehensive program that you'll hear about in detail today, it really is a win-win situation for both the employers and the employee. And this is not only our belief, but it's also the belief of the U.S. Department of Labor. Now, when you look at one particular aspect of this issue, you'll see that substance abuse, tobacco abuse, alcohol abuse is very costly to our nation and to our employers. It's costly in the amount of $700 billion annually in costs related to crimes, lost productivity, and health care. And we see here that illicit drugs accounts for $193 billion of overall cost to both the employers and government. Now, the Partnership for a Drug-Free New Jersey established a program called Drugs Don't Work in New Jersey. And this program is a free program to all New Jersey businesses, no matter how small or large, but it was really set up to be able to provide small and mid-sized businesses with the same opportunities that the larger corporate settings in New Jersey, those folks that have 3,000, 4,000, 5,000 employees, the same kind of opportunities those employers have. We want to be able to provide that opportunity to small to mid-sized businesses. And what I mean by that is we want to be able to provide you with all the tools necessary to establish a comprehensive workplace, drug-free workplace policy. Now, What we've found from our research is Drugs Don't Work in New Jersey, our organization, is the most popular information source on drug-free workplace policies among smaller companies and among top choices overall. We also have learned from our research that 60% of all employers surveyed answering said that they would use the program's resources. So we're hoping that today all of you will be able to access and use our resources. Once again, a free resource for companies throughout New Jersey. Currently, there are over 3,200 New Jersey businesses and organizations that are members of Drugs Don't Work in New Jersey. Now, what happens as a member? The free membership entitles you to a kit, a drug-free workplace kit, which contains model policies, and this was developed by the President's Advisory Council on Substance Abuse. We provide on-site supervisory training, which is a very important aspect of a policy, but also it's a wonderful opportunity to be able to get this training without cost to your company. We provide quarterly updates, which keep all of our businesses informed about topics and also maintaining and updating your drug-free workplace policy. Some of you may have established a policy 5 or 10 years ago. Well, times have changed dramatically. There have been many court cases that have been decided that have changed the course of establishing and maintaining a correct policy, and these quarterly updates are provided by email, and it's a great opportunity to learn about what's new in the field and making sure that your policy is up to date. And finally, as a member, you'll be invited to an annual member seminar, which focuses on all the legal and legislative developments that have occurred over the last year throughout the country and specifically in New Jersey, and how it impacts your business. As I mentioned, over 3,200 businesses are members in New Jersey of the Drug-Free Drugs Don't Work in New Jersey organization. And if you look here at the website, you'll see that there is a direct link on how you can join Drugs Don't Work in New Jersey. So if you get an opportunity, if you do have a pen or a computer handy, I would suggest that you take this information down, and following this meeting, you sign up to be part of this free program that's offered by New Jersey to New Jersey businesses. The drug-free workplace policy exists. Now, why do we have a policy? First and foremost, it's to protect the health and safety of all of our employees, our customers, and the public. It's to safeguard employee assets and theft and destruction. It's to protect trade secrets. It's to maintain product quality and company integrity and reputation. And it's to comply with the Drug-Free Workplace Act of 1988 and other applicable laws. So we're going to hear a lot more about that act, but I just want to briefly discuss the fact that if you do business with the federal government, if you have employees that possess commercial driver's licenses as part of their responsibility in your employ, if you have individuals that are in safety sensitive positions, which means that they can harm themselves or others, then you must comply with the Drug-Free Workplace Act and other applicable laws. So it's really crucial that if you have these employees, that you have a policy in place immediately. But as I mentioned before, whether or not you have any of these employees, it's important that everyone has a comprehensive drug-free workplace policy to protect themselves and to protect their employees. For companies that have this policy, we have found that they have been very effective in some of the more important areas that employers and employees are concerned about in looking at their own businesses. For example, almost 80%, 79% of companies that have policies in place said that it was somewhat or very effective at reducing accidents. 73% said it was effective in increasing productivity. 69% said it was effective at reducing absenteeism. 71% said it was very or somewhat effective at reducing workers' compensation claims. And finally, 59% said it has been effective at increasing morale. Now, as an employer and an employee, we all would like to be able to point to these numbers and make them part of our companies and make them part of our businesses. Now, what I'm going to do at this point is I'm going to turn over the presentation to Steve Trimboli. Steve, as I mentioned before, has been a very active and supporter of the Partnership for a Drug-Free New Jersey. And Steve has been a person who for many years has provided his services to businesses throughout New Jersey in providing them with expert legal advice about drug-free workplace policies and procedures. Steve?
Thank you, Angelo, and thank you all for attending this morning's seminar. We would like to, in this time available to us, give you an overview of some of the more important aspects of the law pertaining to maintaining a drug-free workplace. This is by no means an exhaustive discussion, but just an outline of the key factors to keep in mind, and also your ability to enforce drug-free workplace, including the use of drug testing. As a preliminary comment, we live in a time in which attitude towards substances seem to be changing and be a subject of debate. It's not our purpose today to get involved in that debate, because whether a substance is legal, illegal, or somewhere in between, of critical concern to you is to maintain a safe, effective, and efficient workplace where employees, customers, and the public can interact in safety and protect your investment in your company, protect your business. And again, regardless of whether we're talking about the most illegal of substances or alcohol or even prescription drugs, everyone has a right to a workplace that is safe and that is efficient and that can conduct business properly. I'd like to start quickly with a law that Angelo spoke of, which is the Drug-Free Workplace Act of 1988. This was a law that was adopted in 1988 and is specific to a certain category of companies and businesses. Anyone who is a federal grantee, any federal contract that's awarded to an individual, or any federal contract in excess of $100,000 for services, not for goods, but for services, is subject to the Drug-Free Workplace Act. Now, this requires, among other things, that a covered employer publish and distribute a policy prohibiting the manufacture, distribution, dispensation, possession, or use of controlled substances in the workplace, which is something you should have regardless of any legal requirement. It requires that you establish a drug-free awareness program. You must notify your employees that they are obligated to comply with the policy as a condition of employment. You must also inform your employees that they are required to notify you within 5 days if they are convicted of a drug-related or work-related drug offense. You are then required to report to your contracting or granting agency within 10 days any notification you receive from an employee that they've been convicted for a drug offense that is work-related. Any employee who is convicted of such an offense is required to be penalized or be required to undergo treatment. You are also required to maintain an ongoing good faith effort to keep your workplace drug-free. Now, there are enforcement mechanisms behind this. Payment under a federal contract can be suspended. The contract or grant can be terminated. You can be debarred from eligibility for federal contracts for up to 5 years for violating a requirement of the Act or what the government considers to be a, quote, excessive number of employees who are convicted of workplace-related drug offenses, which would be, in the view of the government, evidence that you are not maintaining a good faith effort to keep your workplace drug-free. The head of the contracting agency may grant a waiver in the public interest or when necessary to avoid severe disruption of agency operations as sort of a safety valve in cases, so it's not mandatory that enforcement action will be taken, but still, if you are a federal contractor and you provide services to the federal government, this is something that you need to be conscious of. You certainly don't want to be in a position of having to explain away or deal with a cancellation of your contract or debarment. Moving on to a more general subject, drug testing in New Jersey, the law pertaining to when and under what circumstances that you can engage in drug and alcohol testing of your employees. I should note that the federal government's annual drug control strategy on an annual basis expressly endorses drug testing in the workplace as a means of controlling drug use. Drug testing and your ability to test and the legality of the testing is divided into different categories and types of tests, and the one that people, I guess, are most familiar with is random testing, which occurs when persons are tested at random selection and at random times to determine whether or not they are under the influence of a substance or have remnants of a substance in their system. Random testing is permitted in both the private and public sectors for employees who hold safety-sensitive positions where there is a need to function safely, and that need is clear. The leading case in New Jersey involved a supervisor at an oil refinery who worked the night shift, and in the words of the court, could blow up significant portions of the facility by throwing the wrong switch. And the court held that that was clearly a safety-sensitive position, and the person holding that position could be subjected to random testing to assure that he or she was operating safely. In another case from 2011, a landscaper at a publicly owned wastewater treatment plant was deemed to be properly subjected to random testing as an employee engaged in safety-sensitive work. So, again, you should take a hard look at your workforce, perhaps obtain legal advice, and make a determination. Are there people working in safety-sensitive positions who could hurt themselves, hurt members of the public, hurt customers, hurt your fellow employees? And if so, that may be an area where random testing is permitted. Now, random means truly at random. The outstanding example would be assigning everybody a number, putting that number into a computer and using a random selection program to determine the number to test. If you have somebody in mind or think that somebody should be tested, that's not random. All right. Finally, for those of you who employ commercial drivers holding CDLs, you should already be aware that you are under a federal law obligation to randomly test a proportion of your workforce every year. That testing is mandatory. You have no option not to perform it, and you should be performing it now. Going through all the details of the CDL regulations would be beyond the scope of what we can accomplish here today, but it's important for you to know the testing is random. Random testing is mandatory, and you should have been applying this for several years now. Another category of testing is called reasonable suspicion testing. This occurs when you have in your possession objective facts which, with logical inferences, would lead you to conclude, or a reasonable person to conclude, that a particular individual is involved in drug-related activity that is taking place or has taken place. One court described it as a sort of common-sense conclusion about human behavior which practical people, including government officials, are entitled to rely upon. It is permitted in both the public and private sector for all employees. This is the sort of testing that has gotten over the years the greatest support from courts, because you have reason to believe that somebody is currently under the influence and you have a right to take remedial action. Again, if you employ commercial drivers, this type of testing has also been mandatory for several years. Now, what constitutes reasonable suspicion? Some examples endorsed by the courts are the following. Personal observation of conduct, appearance, speech, or the odor of alcohol, or other personal observations that would lead you reasonably to suspect that the person is impaired. Information about those sorts of observations from a reliable source or a source that has been corroborated is another basis for reasonable suspicion. Finding an employee having drugs or alcohol on his or her person or in the vehicle they're operating is also reasonable suspicion, or being in an area with limited access where evidence of recent use is present. The outstanding example here is a case that came out of a county correctional facility where there was a limited access area where only 4 correctional officers had access. There was an odor of marijuana. The officers argued that because the employer couldn't identify a specific individual who they suspected, that they could not test any of the 4, and the court rejected the argument based on the reasonable conclusion that since access to the area was limited, only 4 people had access to the area, the class of offenders could only include those 4 individuals. It was permissible to test those 4, even though at that point the employer could not point a finger at somebody individually who they suspected. On the other hand, some examples of what does not constitute reasonable suspicion. Unsubstantiated rumors of drug or alcohol use. You happen to hear from people that Charlie may be using drugs. That's not reasonable suspicion. Poor job performance standing alone is not reasonable suspicion. Committing work rule violations unrelated to substance abuse does not constitute reasonable suspicion. Now, you may have an inkling, or you may suspect that drug or alcohol abuse underlies the poor performance or underlies the substance abuse or underlies the work rule violations. That's not reasonable suspicion that a court would accept. When you have a performance issue or you have work rule violations, deal with them as performance issues and work rule violations. If the employee has a substance abuse problem that he or she wants to disclose to you and ask for counseling in an effort to keep their job, then all well and good. But unless you have actual concrete evidence that will provide you with a reasonable suspicion that a drug or alcohol violation is occurring, deal with performance issues as a performance issue. In New Jersey, there are also, the law permits the testing of job applicants for private sector employers. It is permitted when all applicants are tested and when the testing occurs pursuant to an announced and established policy that is made known to the applicant. Some of you may have shopped in stores where a chain store where they will prominently put on the door, "We test all applicants." That's part of the announcement of the policy that will allow that employer to test applicants as part of the employment process. Again, if you employ commercial drivers, this has been for quite some time mandatory that applicants be tested for CDL positions. The law also requires that you obtain releases from the applicant to inquire from previous employers whether they had been involved in any drug-related misconduct while at work. In the public sector, if you're a public employer, applicant testing is permitted only for those who are being hired for safety-sensitive positions or who work in highly regulated fields such as law enforcement. Drug testing in certain circumstances is also permissible in connection with annual physicals. In both the public and private sector, employees who hold safety-sensitive positions, whether the need to function safely can be clearly established, can be tested as part of their annual physical or annual physical capacity examinations. But again, as in the case with any annual physical, because of the Americans with Disabilities Act, testing can be or the physicals can be conducted only when they are job-related and consistent with business necessity. There are 2 specialized categories of testing that the law recognizes. One of them is return-to-duty testing. This constitutes the testing of an employee prior to his or her return to work when that employee has previously tested positive for substance abuse or has otherwise been found to have abused substances. It is permitted in both the public and private sector, especially when it is conducted pursuant to a last chance agreement. Last chance agreements are enforceable both under state and federal law, and random testing has been held not to violate a public employee's Fourth Amendment rights because, among other factors, the employee, by signing the last chance agreement, consented to the testing. Similarly is the concept of follow-up testing, which is permitted both in the public and private sector in New Jersey. Follow-up testing includes a testing of an employee who has returned to work after either having tested positive or having been found to abuse substances, and it is used in order to determine whether the employee is continuing to maintain a drug-free and drug-free behavior and alcohol-free behavior at work. It is permitted in both the public and private sectors, as I stated, especially where there is a last chance agreement in place, particularly with respect to controlled substances. Again, this is mandatory for any employer who employs commercial drivers, and has been mandatory for several years under federal law. The duration and frequency of follow-up testing is ideally to be determined by a substance abuse professional. Under the federal law, you're required to obtain the advice of a substance abuse professional who can tailor the follow-up testing specifically to the person at hand. If it's somebody who just happened to test marijuana once and happened to be caught, the follow-up testing will be significantly different from somebody who had a long-term problem and is working very hard to recover from an addiction. But again, you should, in a case of follow-up testing, receive a recommendation from a substance abuse professional and not adopt a one-size-fits-all approach. Now, follow-up testing in alcohol is treated a little differently. And the reason for that is alcoholism is considered a protected disability under both federal and state law. As a result, it has been held that a blanket requirement of follow-up testing for somebody who had tested positive for alcohol or had volunteered for alcohol counseling constitutes potential unlawful discrimination. What you need to do is make an individualized assessment of the employee, the position the employee holds, and whether there is an objectively reasonable belief that the employee will pose a direct threat to safety or health without follow-up testing in the case of alcohol. That is a requirement of New Jersey law that will apply to most employers under New Jersey law. However, if you're an employer of commercial drivers and you're dealing with commercial driver's license holders, the federal law trumps the state law. You must engage in follow-up testing, even if it involves alcohol. But for non-CDL holders, you have to engage in the sort of individualized assessment of who the employee is, the position the employee holds, and whether there is an objectively reasonable belief that the employee will pose a direct threat to health or safety without follow-up alcohol testing. Another category of testing in New Jersey that's permitted, again for both the public and the private sector, is testing of an employee immediately following an accident in which the employee was involved or which the employee caused. That would tend to constitute reasonable suspicion, particularly if there's other evidence of substance use on hand, or if the employee is employed in a safety-sensitive position, or you have an established policy of testing post-accident. For commercial drivers, it is mandatory under federal law that post-accident testing occurred. And those are the forms of testing and the situations in which drug testing is permitted. Another category of issues that you have to bear in mind as well is how the testing is conducted. The courts have recognized that drug testing, which generally for drugs involves the presentation of a urine sample from the employee, raises privacy issues, and the courts have held that testing must be conducted in a manner that protects the privacy, confidentiality, and dignity of the subject. You don't want to do what one employer did and simply tell all the employees to line up by the men's room and the ladies' room while a supervisor stood in the doorway and watched the production of the urine sample. That whole testing procedure was thrown out, and the employer was deemed to have violated the privacy rights of employees. You're well advised to use a professional service. There are services, there are labs that will provide testers. There are other private companies that will do the testing and will forward the substances to the labs for you and maintain chain of custody. That you are well advised to follow that course. Direct observation of a urine sample is allowed only in limited circumstances where there is evidence that the employee may be providing false or adulterated samples. The federal law for commercial drivers now requires direct observation for employees who are undergoing return to duty and follow-up testing. New Jersey has not yet gone that far. The federal government's position is that if you are If you tested positive and you went through counseling, you're returning to work, and you are undergoing follow-up testing, there's reason to believe that you might be tempted to provide a false or adulterated sample. The New Jersey courts haven't yet, as I said, gone that far. So direct observation in New Jersey in non-commercial driver cases should only occur where you have evidence that the employee is attempting to provide a false or adulterated sample. One such form of evidence would be a urine sample that is at a temperature different from what we would expect to come from a human body, or a urine sample that is so acidic that it couldn't possibly have come from a human being. Those are examples where the employee would be asked to give a new sample and do so under direct observation. If you are a unionized employer, there are union issues that you have to deal with as well. In the private sector, you are required to negotiate with the union over the decision to test, over the substantive aspect of testing, over privacy and confidentiality issues, and over the discipline that will result if an employee tests positive. In the public sector, it's been held that you have a government policy right to implement testing and to implement the substantive aspects of testing. The union cannot ask you to negotiate over that. However, you must negotiate with the union, even in the public sector, over privacy and confidentiality issues and over discipline. The one caveat is, again, if you're an employer of commercial drivers, federal law mandating testing for commercial drivers and mandating removal from safety-sensitive functions for any driver who tests positive trumps everything else, including any union contract or any union demand to negotiate. Alcohol testing is considered a medical examination under the Americans with Disabilities Act and under New Jersey state law, again because alcoholism is a protected disability, and therefore alcohol testing is treated a little differently. An alcohol test can be administered in a pre-hire situation only after a conditional offer of employment has been extended to the employee, just like any other medical examination under the ADA. Post-hire, alcohol testing can be conducted only when job-related and consistent with business necessity. A reasonable suspicion situation would clearly fall within this category. Random testing, you would have to demonstrate that the need to random test for alcohol is job-related and consistent with business necessity. So again, the key point to remember is that an alcohol test, unlike a illegal substance test, is considered a medical examination and is subject to the same limitations that our state and federal disability discrimination laws apply to any medical exam. Moving on to touch briefly on the medical marijuana law in New Jersey. New Jersey is one of the states in which marijuana use for medical purposes is permitted. It is technically an exception to the criminal law that would otherwise subject an individual to prosecution for marijuana use. It is permitted, as generally speaking, a limited category of qualified patients and their primary caregivers with proper written authorization from a treating physician may purchase and utilize limited amounts of marijuana. Qualified patients are required to purchase medical marijuana from organizations licensed by the states known as alternative treatment centers. So that is generally what the law provides. There are also limitations that I think we're going to focus on here today. First, there is no protection offered to any person, even if they are otherwise certified and licensed and are operating under a physician's recommendation. If that person operates, navigates, or is in control of physical equipment, any vehicle, any aircraft, any railroad train, any stationary heavy equipment, or any vessel while under the influence of marijuana, the law does not protect them. Nor does the law permit smoking marijuana in any form of public transportation, including a school bus, in any private vehicle unless a vehicle is not in operation, on any school ground, in any correctional facility, at any public park or beach, at any recreational center, or any place in which the smoking of tobacco is prohibited. Since tobacco smoking is prohibited in virtually every workplace in New Jersey, it necessarily follows that medical marijuana cannot be smoked in any workplace in New Jersey. It is also a criminal offense to falsify registration information or registration cards. Of specific note to employers are two aspects of the law. First, you are not required to provide health insurance coverage for the costs associated with the medical use of marijuana, and employers are not required to accommodate the use of medical marijuana in any workplace. This language is similar to what we see in every state that has adopted a medical marijuana statute except Maine, and although New Jersey has not yet directly addressed the issue, in every state except Maine, it has been held that an employer is not required to create a deviation or exception to its workplace drug testing policy for medical marijuana users. You can still test individuals, and if they test positive for marijuana, you can take corrective action or remove them for safety-sensitive functions, even if the marijuana use was pursuant to a medical certification. The only exception, as I said, is Maine, and that is because Maine's statute prohibits employers from doing that. No other state, including California, has a similar provision in the law. The language in our statute was modeled on the California statute, so it is our conclusion that under New Jersey law, you are still permitted to enforce workplace rules pertaining to marijuana use, even if the use is as a result of a medical certification. Now, I want to briefly touch on the American with Disabilities Act and the Family and Medical Leave Act as it applies to drug and alcohol abuse in the workplace. Two things to remember: even though the ADA only applies to employers who have 15 or more employees, the ADA also tracks our state disability law. So what we say here about the ADA would also apply under state law, and therefore everybody who's an employer in New Jersey is subject to this. Under ADA and state law, you cannot remove or discipline an employee for who requests an accommodation for a protected disability. You must engage in a reasonable good faith give and take once the employer places you on notice of a disability and the need for an accommodation. Now, the question is, to what extent is drug and alcohol abuse a disability? Alcohol use, as I said, is considered a disability because alcoholism is a disability. However, current drug use is not considered a disability under state or federal law. Having a history of drug abuse is considered a protected disability. Being erroneously considered to be a current drug user is also a protected disability. Now, what constitutes current use versus past use? The case law tries to define that and says that any person whose use of drugs was reasonably close in time to give rise to an inference that the employee is still involved in drug use can be considered a current drug user. Somebody who tested positive in June and went for treatment in July, it's now August. The courts have said that's not enough to make the drug use part of the past. You need a longer gap of time of non-use. You need some evidence that you've been treated for it and you've given up the habit, and need to go further than a month or two without use in order to be considered a past user versus a current user. So rule of thumb is current drug use is not a protected disability. Current alcoholism and past drug use is protected. Under the Family and Medical Leave Act of 1993, as many of you know, this provides leave of up to 12 weeks for, among other factors, the employee being unable to perform job functions due to a serious health condition of at least 3 days duration. In the case of drug and alcohol abuse, you're entitled to leave for treatment. You're not entitled to leave for use. And the controlling regulation makes this point clear. FMLA leave may be taken for treatment for substance abuse by a provider of health services on referral by a healthcare provider. In other words, you can take leave in order to receive treatment. You are not entitled to take leave for use, and what's more, even if you take leave for the purpose of treatment, that does not immunize the employee from any existing established drug-free workplace policy that may be in effect, as applied in a non-discriminatory manner, and has been communicated to all employees. In other words, you adopt a policy prohibiting drug use in the workplace or alcohol abuse in the workplace. You enforce it uniformly. It's established and communicated to all employees. The employee may still be subject to discipline even though he asks for and receives FMLA leave to undergo treatment. A request for treatment does not forgive or immunize you from treatment, and again, it has to be treatment under a healthcare provider, not just the employee's representation that he or she may be seeking treatment. A tougher issue arises with the question of prescription drugs, which is a subject of ever-increasing abuse in the workplace. Generally speaking, under the disability laws, employers cannot ask employees to disclose the prescribed medications they are taking. And that, again, the key to remember here is that prescribed medication by a doctor. In safety-sensitive environments, you can ask employees to disclose whether they are taking medications that may impair them, not the specific type of medication, but ask whether that the medication is impairing, in which case you can then take action to determine whether it's safe to continue to keep that individual in that particular work assignment. You can ask for a medical report, again, not to tell you necessarily what the medication is, but to tell you what the side effects may be and whether or not the employee can safely perform their functions. Pre-employment, you cannot inquire about prescribed drug use. You may, however, explain to the employee that being unimpaired is an essential function and ask if the applicant is able to meet this requirement. And the applicant will then be under an obligation to say, yes, I can, or no, I can't. If they tell you that they are, and it later turns out that they are impaired, then they've made a false statement during the application process, and you can address that. Quickly to talk about the Genetic Information Non-Discrimination Act of 2009. This is a federal law that prohibits discrimination on the basis of genetic information. What would that have to do with drug use, you may ask? Well, genetic information under this law falls into two categories: genetic tests, which is obvious, and also any manifestation of a disease or disorder in the employee's family members, which under law means any family member or relative from the first to fourth degree. Any manifestation of an illness or disorder is considered genetic information theoretically, because I as an employer can then assume that whatever the family member is suffering from, you are genetically predisposed to. As a result, this means that any information about drug use or alcoholism, past or current, of a family member is considered protected information. You cannot inquire about it. You cannot discriminate on that basis. And if any information comes into your possession, such as an employee disclosing to you confidentially that his or her son is going for drug or alcohol treatment, you must keep that confidential. Some areas where there's legal sensitivity that you're going to need to address, as we discussed here: maintaining employee confidentiality, assuring that any policy you adopt is clearly communicated, establish procedures to thoroughly investigate alleged violations, provide due process and ample opportunity for response to allegations when they arise, determine drug testing eligibility. If testing is included in your policy, ensure quality control and confirmation of positive tests, and conforming to union contracts where applicable. In addition, if an employee learns that an employee has engaged in illegal activity while employed by the employer, even off duty, it is not something you necessarily have to ignore. On the one hand, the employee has no right to engage in illegal activity. On the other hand, there are cases where the employee's off-duty conduct will reflect on your company and your company's reputation, and that's something to consider as well. Now, I realize I've gone through an awful lot of material here. We are here to take any questions you may have, And with that, I'll turn the floor back over to Angelo.
Thank you, Steve. That was extremely informative, and I think it provided a great overview of what an employer must, the knowledge they must have in order to have a comprehensive drug-free workplace policy. And there are some additional guidelines that are in place that the Small Business Administration specified, and we have 5 components of what a comprehensive drug-free policy should be. First of all, a clear written policy that is distributed to all employees, that there is sufficient time for the employees to answer or ask any questions they might have about the policy, and there should be a sign-off that the employee has read the policy, understands the policy, and has been given sufficient time to provide any questions about the policy. Once the policy is in place, there should be a minimum of 2 hours of training for all employees, and certainly additional training should be available for employees not only as an employer, but also as a parent and a grandparent. So it's a great opportunity to provide additional services to employees. Drug testing by a certified institution. There are numerous certified institutions in the state of New Jersey. When you join Drugs Don't Work in New Jersey, with the kit, you will receive a list of all of the New Jersey certified labs. Access to EAPs, once again, in the drug-free workplace kit that you'll receive free of charge is a listing of employee assistance programs that are available at a county basis and statewide. And finally, continuing drug and alcohol abuse prevention programs that are also provided by the Partnership for a Drug-Free New Jersey to your employees and free of charge once again. Now, the New Jersey Business and Drug-Free Workplace Policy, currently 78% of New Jersey businesses have a drug-free workplace program. And of those, 99%, almost all, are large businesses, but only 60% are small businesses. So once again, I think you can understand the reason why this organization was put into place was to provide the small businesses with the same opportunities as the large businesses in the state. And most adopted these policies because they were required to by law or by contract, or also some of them put it in place to reduce workplace accidents, and 13% did so on the recommendation of their insurance carriers. Now we are seeing this become more and more prevalent where insurance carriers are asking a question about whether or not you have a comprehensive workplace policy, drug-free workplace policy, before they will insure you. Now, what should a drug-free workplace policy answer? It should answer the following questions: the purpose of the policy and the program, who is covered by the policy, who is responsible for implementing the policy, where and when does the policy apply, and what behavior is prohibited. And I just want to spend a few moments on number 2, who is covered by the policy. We heard the language safety sensitive positions, and we also heard commercial driver's license positions, CDLs. Well, for those that are safety sensitive, it is important, as well as for those who hold commercial driver's licenses, to specifically identify those positions in your policy as having to go through both random drug testing as well as other options that you may deem responsible. Finally, the NIDA, National Institute on Drug Abuse, suggests testing for the following substances, which commonly referred to as the NIDA 5, which are the 5 substances on the left-hand side, the amphetamines. But we are seeing, because of the epidemic of prescription drug abuse in New Jersey and throughout the country, that many companies are also adding opiates, marijuana, cocaine, and other drugs to the drug testing programs that they have within their employee. Finally, the Partnership for a Drug-Free New Jersey offers programs not only for the workplace, but also for families, for communities, for schools, and we would ask you to take advantage of these programs. If you are involved with a PTA or PTO, if you are part of any community group, religious organization, we'd be happy to come and visit and explain to you how we can provide free services to those organizations as well. I just want to conclude by once again thanking the New Jersey Business and Industry Association for giving us this opportunity, and we are happy to address any questions today or in the future. Thank you.
Thank you so much. That was a lot of information in a short period of time. Again, the presentation will be emailed to you along with a recording of the webinar, so if you missed something, you can go back and find it. We did have a question during the presentation about the permissibility of drug testing following an accident. That question came in right before Steve covered that in his presentation, but I was just wondering if you could talk maybe a little about the difference testing after an accident as opposed to random drug testing or testing because of suspicion of drug abuse.
Sure. The post-accident testing originally arose under the federal government regulations, not just for commercial drivers, but for railroad operators and nuclear power employees. And the case that gave rise to it occurred in, some of you may remember, back in the 1980s. There was an accident in the New York subway system, and the motorman who was running the train that was involved in the accident was later found in a bar on his fifth scotch. And his explanation was, I was so distraught by what I did that I needed to drink it off. And by doing so, he effectively denied the city any ability to test whether or not he had been impaired at the time of the accident. To prevent things like that from happening, that is why the federal government, for those class of employees, adopted the post-accident testing requirement. For others, it is very similar to the reasonable suspicion issue. It's that if you have reason to believe that the driver is impaired and the driver is involved in an accident, you can test to determine whether or not there were substances that played a causative role. We're talking here about vehicles on the road. We're talking here about heavy equipment. Or if you have an established policy that says that when an accident occurs as part of our investigation, we will conduct this type of testing to determine whether or not you were impaired, that too is permissible. That is it's different from random, obviously, because you're not picking anybody at random or at random times. It's that you have a specifically identified person, and it's part of and it's different from reasonable suspicion because it would be under your policy part of a regular, general, and consistently applied rule pertaining to investigation of accidents.
Thanks. That was a great answer. Most of our members here at NJBIA are small businesses. So for the 40% or so that don't have a drug-free workplace policy, one of the things we find with the small businesses, they have to do everything themselves, the business owner or manager. How hard is it to put together an effective drug-free workplace program? And, how can small businesses be assured that this isn't going to interfere with daily operations?
Thank you for that excellent question. Most of the members of Drugs Don't Work in New Jersey are small businesses. Those businesses range from 2 or 3 employees to sometimes as many as several hundred employees. But for those companies that are out there that have maybe 15 or 20 employees, or more or less, the Drugs Don't Work policy kit that's provided to all of our members free of charge is really a turnkey assistance to those businesses. It provides a sample policy. It provides the locations of drug testing facilities within their county and community, the costs of those tests. It also provides resources, in-person resources. We have individuals in our office that will go and support and assist a small business in establishing a drug-free workplace policy. And our quarterly updates are an excellent tool with specific language changes that we recommend based on cases that are being decided both in New Jersey and throughout the country. So I think that it is a very important aspect of protecting your employees as well as protecting your company. And within a 30 to 60-day period using the drug-free workplace kit, we are confident, based on other companies, that a company will be able to implement this policy within their organization.
Okay, thank you very much, Angelo. I hope everyone has taken a moment to write down their contact information. Angelo Valente, Executive Director of the Partnership for a Drug-Free New Jersey, and Stephen Trimboli, Esquire of Trimboli and Pruzanowski. Thank you, gentlemen, for an excellent presentation. That's about all the time we have today, so we'll have to bring things to a close. Don't forget, all of you will be receiving a recording of today's webinar and a copy of the presentation via email. Also, we will send you a survey that we hope you will fill out so we can understand how best to provide you the important information in a webinar format. Our next webinar will take place on Thursday, September 24th at 11 a.m. and cover the topic of cybersecurity. I would also like to thank our producer, Vinny Civitillo, who is a great part of our webinar team, for pulling this all together. So again, for Angelo Valente and Stephen Trimble,